Morning, Greg Willard.
Good morning, McGraw.
All right. What happened Friday late afternoon as they were trying to close the doors?
In fact, I think maybe it was after they closed the doors, but the governor, Greitens, was charged in a 2-count complaint with 2 felonies. Felony computer-tampering with respect to some donor lists, which we can get into.
Right.
And that complaint was filed with the clerk of the court at about 5:30 on Friday, McGraw.
When you were here earlier last week and I asked you, does this mean he's going to be arrested again if this comes down and another mugshot? And you said, yeah, probably. How come he wasn't arrested, and how come he didn't have to post bail, and how come there's no mugshot?
He was not indicted. You remember we talked on the air that whether he'll be charged or indicted,
right.
And the circuit attorney chose to charge him in a complaint. So there will be an arraignment, a preliminary hearing, and then it will proceed to trial. The intervening difference between this case, McGraw, procedurally, and the felony invasion of privacy charge he's facing is there's not an intervening preliminary hearing. The preliminary hearing, if you will, is taken care of by an indictment, and since he was charged on Friday by a complaint, there very likely will be a preliminary hearing before the trial.
Oh, will the preliminary hearing, we'll hear lots of juicy stuff?
You'll hear some. What the preliminary hearing is it's for the court to decide on its own whether there's probable cause to believe that a crime was committed. It's not even fair to call it an abbreviated trial. There may be one witness, maybe 2, very short testimony. The defense does not put on any witnesses, so it's called a preliminary hearing.
What did we learn Friday about the allegations? Was he using these lists, they say, before he was elected? Was he using these lists after he was elected? What do we know about these 2 counts?
Well, let's see if we can set the stage for our listeners, McGraw, and we go way back. Many years ago, the governor, before he was governor, obviously, established this entity called the Mission Continues,
right.
and they have done, by all accounts, terrific work. In January of 2015, as he began his gubernatorial exploratory committee, he obtained a list of prospective donors, and let's just put a little mark there, January of 2015.
Okay.
The complaint on Friday, McGraw, alleges that on April 22nd of 2015, he obtained the Mission Continues donor list.
Okay.
Last August, the governor admitted that the acquisition of the January 2015 list was a violation of Missouri campaign laws, and he paid a fine.
Right.
In early 2017, Attorney General Hawley begins an investigation as to the April 2015 list. I would note, at the time, his political opponents called the Hawley investigation a, quote, sham, close quote.
Right.
Earlier this month, the House of Representatives Impeachment Committee handed up their report, and a lot of people didn't pick up on it. You had it, and we discussed it on the air. There is a section of that report that says the investigation of the Mission Continues donor list continues. Last week, the Attorney General announced that his office had found probable cause that the governor had committed a crime with respect to the April 2015 list. He turned over that evidence to the circuit attorney last week, and last Friday, she filed charges, 2 felony counts against the governor for computer tampering with respect to the April 22nd, 2015 acquisition of the Mission Continues donor list.
What's the big deal? I'm with Ed Dowd. Ed Dowd says the guy started the charity. He created the list. Why can't the guy use the list?
Well, Ed Dowd is absolutely correct. The governor, I think, almost single-handedly began the Mission Continues, and I think even the governor would admit that lots of people have been part of its success. And so to that, in that respect, I agree completely with my former colleague and friend, Ed Dowd. However,
hold on, former colleague, still friend, Ed Dowd.
former colleague and still friend. Yes, yeah. Thank you, my grammatical corrector.
My still correct.
Yeah,
Okay, right.
yeah.
All right. Just wanted to make sure.
We were colleagues for many years, and we were and continue to be friends.
Okay.
But anyhow, the point is this. Just because, McGraw, that somebody sets up a corporation and puts their blood, sweat, and tears into it, the assets of that corporation are the corporation's assets, not the shareholders, not the creators. They are the assets of the corporation. In addition, and this is very important, the corporation in this case is what is called a 501c3 not-for-profit corporation.
Right.
And it is kryptonite, McGraw, absolute legal kryptonite for a 501c3 to do anything that even remotely affects or assists a political candidate or a political campaign. And the fact then that the allegations are that the governor, without authorization, knowingly obtained the Mission Continues donor list. That is at the core of what the circuit attorney has alleged is a felony of computer tampering.
Greg Willard with us, our KTRS Legal Analyst, St. Louis University Law Professor. Let's change the subject to this current trial. The second trial, or the second indictment, or the second charge, if you will. The first charge, whatever it is. All right. What's good for the goose is good for the gander. What type of discovery is Kim Gardner allowed to do to find out about the list? Who he emailed it to? Can she subpoena or get his computer records? Is this list going to then find out who gave him what amounts of money? Because there are lots of people sort of like, well, wait a minute, what is this, right? All these non-disclosure things. How much of this list and who he emailed and how much they gave is going to be researched by the prosecutor?
Let's see if we can put a couple of fence posts down for our listeners, McGraw. Just because there is a criminal charge or in civil court, just because there's a charge pending and there is discovery, doesn't mean that either side can get whatever it wishes. It is not a court-sanctioned fishing expedition. Mm-hmm. On the other hand, both sides should be able to access not only evidence that is relevant, but also information that reasonably can lead to finding relevant evidence. So, what the amount of money that donor Smith gave in Boise, Idaho, right. I don't think that's reasonably calculated to lead to admissible evidence, McGraw. So you begin to then draw it in. I think I'll just sort of tea leaf it for our listeners on a Monday morning. I think it is highly unlikely that the judge who is going to be assigned to this case is going to allow either side to go fishing into the personal contributions of people to the campaign. And the primary reason for that is this, McGraw. The governor has been charged with felony computer tampering. Mm-hmm. There is nothing in that statute that deals with campaign contributions or who gave how much and when.
Right.
And so if you just look at the four corners of the statute under which he is charged, mm-hmm. the idea of going fishing on that is highly unlikely. Having said that, let me also say that both sides will have the Mission Continues donor list. Obviously, according to the complaint, the governor already has it.
Right.
And presumably the prosecutor will get it. Let's then go a little further with the tea leaf and say, well, what if that comes into evidence at the trial?
Right.
Well, as we all know, evidence at a trial is a public record. I think it is reasonable to expect that
we're all going to get the list at some point.
we could, but I think it's more likely, McGraw, that the judge is going to say, I'm going to seal. I'm going to seal that list because it contains proprietary information, personal information, right. and the like.
Yeah.
So the jury will see it
yeah.
and can do whatever
right.
they want. But I think the idea that our colleague Tony Messenger and others at the Post-Dispatch are going to see it as unlikely.
All right. Why was the governor charged, but not the woman and the man who sent the list to him? They are just as guilty.
KT.
Yeah, KT. Where are the charges on KT and the other ones?
We don't know. It could be that KT is a cooperating witness. On the other hand, given the speed with which this charge came down, the Attorney General turned over his report early last week, and on Friday afternoon, the charges are filed, McGraw. So it may be that KT is cooperating, and as part of that cooperation, she's not going to be charged. It may be as simple, McGraw, as the clock ran out because we have a statute of limitations issue.
Right.
And it may be as simple as they didn't have enough information to charge KT, and therefore she's sitting here on a Monday morning thanking her lucky stars that somebody centuries ago came up with a statute of limitations.
Right, because now they can't go back and charge her because it's passed yesterday.
Exactly. The statute passed April 22nd is the allegation, and so on come April 23rd.
Well, they also lose some leverage with this KT as well, right? Because now they can't. She doesn't need to flip with it.
Well, they use leverage in one sense, but in another sense they don't, McGraw, because she's going to have to testify under penalty of perjury.
Oh yeah.
It's sort of like you get a pardon, now you can't take your Fifth Amendment, exercise your Fifth Amendment. So so the good news for KT may be she can't be charged with felony computer tampering. I wouldn't call it bad news. The reality for KT is she's going to have to raise her right hand
and tell the truth.
And if she doesn't, Houston, we have a problem.
Yeah. Huh. Never a dull moment around here. That's why he's the best in the business. Greg Willard, professor at St. Louis University, KTRS Legal Analyst. Keep your phone on.
I certainly will.
7:31.